Good morning, everyone. Welcome to UK Chamber of Commerce. We call it UKGCC. This is our maiden session on mandatory compliance for businesses in Ghana. And today we'll be hosting Mrs. Jemima Oware. She's the Registrar General of Ghana, and I will take time to introduce her. But before I do so, I want to say special greetings to the directors of the UKGCC and also all of you on the line for making time to join us today. Mrs. Oware attended Wesley Girls and completed in 1979. She's a lawyer in Ghana and was called in 1984. She started a career in 1987 at the Attorney General's Department and rose through the ranks and became acting Registrar General in 2015. And as of 2017, she became a substantive Registrar General. She's a commissioner at the Securities and Exchange Commission. She was part of the committee of experts that drafted the company's law, which was passed in 2019. She was also a key member or key expert in with GARIA in the passage of the Corporate Insolvency and Restructuring Act 2020. She has all the expertise to give us what we need to know about compliance required from businesses, whether limited liability, whether a public liability company, or whether a trust. She has all that it takes. A lot of changes have been introduced by the Companies Act, and it's important that businesses are aware of the obligation to avoid any exposures or pecuniary penalty which may be imposed by law. So we have Mrs. Oware. Mrs. Oware, you're welcome.
Thank you.
And you'll have your audience.
Thank you for having me. Could you please go on to my outline? Yeah. Briefly, I'm going to give you an introduction to who we really are, and I'll give you some highlights of Act 992 and other requirements you need to know, and then we'll go through the conclusions. The Registrar General's Department is the first point of call for every business in this country. By that, what we mean is that you cannot do business in this country unless you come through us and get registered. And so we then are responsible for giving you life, as well as ensuring that you are properly dissolved. And we do all this with payment of fees. But we are really partners to the business community, and we are here to ensure that businesses succeed. And it should be done through an easy mode of doing business. And we also serve as a one-stop shop for starting any business in this country. As I go on, you see how we are a one-stop shop. Now, who we are a department under the Ministry of Justice, and we are the sole authorized institution responsible for the initial registration, the maintenance. We are the custodians of the data we produce from all these registrations in businesses, companies, professional bodies, administration of estates, registration of marriages, and industrial property rights. We administer all these various sections I've given to you. So our main mandate is to ensure that efficient and effective administration of these laws which we govern are there, providing you with also customer-friendly registration services. We are supposed to compile all this data, accurate, timely, for national planning, as well as the business community and the public at large. We have 5 offices. The headquarters is in Accra. Our second office was in Kumasi, and then now we've set up one in Takoradi, was in Sunyani. These are some of the laws that we govern. You see that the main one is the Companies Act 2019, Act 992, the Incorporated Private Partnerships Act 62152, Registration of Business Names Act 62151, the Corporate Insolvency Restructuring Act, which came to repeal the Body's Corporate Official Liquidations Act, which we had been using for so many years, since 1963. This is the new legislation that has come to Insolvency Restructuring Act. It's a particular section that gave powers to the official liquidator to go to the courts to have a company wound up because it's unable to pay its debts. We've had to go back to have an amendment done for this to be done. And this is the new act in place. We also register trademarks. It's also been amended. We register textile designs all under the Industrial Designs Act. We register patents. We administer estates, Marriages Act, Cap 1 to 7. The Marriages Act, we only deal with special licenses where we do away with the notice and we're able to register in any part of this country. And we also register professional bodies under the Professional Bodies Registration Act. Quite a number of pieces of legislation. Please, let's go on. Now, the main reason we are here is about the Companies Act, and it was passed on the 2nd of May 2019, and it was assented to by the President on the 2nd of August 2019. It replaces the Companies Act 1963, Act 179, which we've used for the past 56 years. This new act that we have currently is very forward-looking. It introduces more robust laws on corporate governance, beneficial ownership disclosures, and it promotes the ease of doing business. Now, unfortunately, the regulations and guidelines of this act are yet to be drawn up and published. We need to have a board in place. The new office that's going to be set up, we need to have a board in place before we can have these regulations and guidelines passed through Parliament. So we're hoping that before the end of 2021, at least we'll have it in place and then be able to share it with practitioners. Now, some of the highlights of this new act are, first of all, is the establishment of an office to be known as the Office of the Registrar of Companies, the ORC for short. And then we're also going to be telling you about the suffixes to names of companies. I'm going to be telling you about the new terminologies in the system, such as we are now dealing with a constitution. Financial terms have also changed because of the new regime that we have now put, governance and transparency, and the beneficial ownership disclosure. I've talked of that. The IFRS is the new reporting standard. This is very new. We have provisions on major transactions, derivative actions, mergers and acquisitions, buyout for dissenting shareholders, registration, communication, and service by electronic or digital means, companies bulletin, and enhanced sanctions. These are a few of the changes. When we come to the establishment of the Office of the Registrar of Companies, it's a body corporate with perpetual succession. This office is going to be able to acquire and hold property and enter into contract or any other transactions. And this office is going to have financial autonomy, which is very key to be able to be successful and do what the Act says we should be doing. And the registrar is going to have a seal that bears the words Registrar of Companies Ghana. The Office of the Registrar of Companies is going to be decoupled from the current Registrar General Department. It's going to have its own 11-member board of directors, and a Registrar of Companies that will be different from the Registrar General. Now, the functions of this office, the office, it shall be established. It has to be established within 2 years of the coming into force of this act. Already we are very late. The act came into force in 2019. And so August of 2021, we should have had this office about ready to be commissioned, but we are even struggling to get land. But that is what the law is saying. We should make sure that it's set up before August 2021. So there's a lot of work to be done this year. The main function of this new office is to register and regulate all types of companies in conformity with the Act and other relevant enactments. So it's not going to be only registering companies. This office is also going to be registering business names under Act 151, partnerships under Act 152, and professional office will be able to appoint inspectors. We have companies and managers to ensure compliance. It's going to discharge and perform official liquidation functions under Act 1015, manage the finances and fixed assets of the office, and undertake educational programs, because there's a lot of education. This webinar we are hosting, for instance, is one of them. You need to know what is happening. Now, we're going to be very strict on inspection and compliance. We have been doing it, but this time it's going to be enforced even more. By the Section 228 of Act 992, the registrar may, by written order, call on companies to produce for inspection all or any of its books. And for investigation purposes, the registrar may settle or deal with matters which could arise from the registration of businesses in the country, be it from the courts or directors or members or the registrar's sole motu. And to ensure compliance in the business community with respect to these various acts that we are going to be managing, be ready for a team of company inspectors that will be coming around your the various registered offices of companies for inspection of its books as required by law. Now, one of the first changes we'll be discussing is the fact that we are going to replace the term regulations with constitution. And companies are being given the option to file a registered constitution. This constitution should be signed by one or more subscribers or the company secretary, and it may either be delivered to the registrar before incorporation or filed after incorporation. And should a company fail to file a constitution with the registrar of companies, the standard constitution as contained in the different schedules to this act would be applied to that company. So by that, applicants would just need to fill any of the prescribed Form 3s that we put out on our website for each type of company. And you can indicate on this form whether you want to adopt the standard constitution that has been put out through the schedules, or you would want to come up with your own registered constitution. Fixes that we have also now come up with that you will need to comply with under Act 992. Please, if you can go to the next slide. You will see that for a private company, there are now suffixes that should apply to every type of, okay. So if you look at the next slide now, for a private company limited, we used to have limited ending the name, and that would have been maybe LIMITED. Most companies have that name. It's changed now. All companies that have the full limited ending the name would have to change their names to either LTD or limited company as ending the name. The form that you need from our website is a Form 3. And the type of constitution you also need is found in the second schedule in Act 992. For a private and limited liability company, the end of the name is either going to be private and limited company or PRUC, P-R-U-C. And the form is a Form 3A. You can also find that in the second schedule. For private company limited by guarantee, the ending is now LBG or limited by guarantee, and the form is a Form 3B, and you can find that in the fourth schedule. Please go to the next slide for me. The public thing should be PLC or public limited company. The form you use is a Form 3C, and it can be found in the third schedule. For a public and limited liability company, it's either PUC or public and limited company. The form you need is a Form 3D. You get that from the third schedule. The last is a public company limited by guarantee. You have the end is PLBG or public limited by guarantee. The form is Form 3E, and you can get that from the fourth schedule. Now, the ultra-vires rule has been relaxed in Act 992, and the Companies Act by this does not require companies to file an object clause if you are coming with your own constitution. You then need to file an object clause. But if you want to adopt constitutions that have been put on the website, you would not need to file an object clause with us. Because a company in our system you have to indicate on the Form 3 which sectors you'll be operating in through the International Standard Industrial Classification. People request information from us wanting to find out which companies are in a particular sector. So the fact that you don't file an object clause doesn't mean we shouldn't at least have an idea which companies are in which sector. So you would need to comply with that requirement. But the whole idea is a company has the full capacity to carry out any business or activity unless specifically restricted by its constitution. So without the object clause, the company has the capacity of a natural person. However, the rules governing approval of the names by the Registrar of Companies will still apply with regard to the name of a business and how it can restrict a company to only specific objects to operate in. For instance, if you have in your name construction, or and in the name you classify an object or one of the objects in the name, it will restrict you to only those objects. So if you have properties, realties, and then that's what you put in your name, you can't be seen to be doing general trading. So that will restrict you. Now, another thing is, another exception to this is a company, we've said that already, a company set up for special purposes or operating in a regulated sector, such as banks or security companies, would be required to state the nature of their proposed businesses in the constitution to be submitted to us at the constitution. You can't just adopt what we have. And now companies with foreign participation will also still have to comply with the GIPC rules on minimum equity requirements, and would also need to file a registered constitution. If you have foreigners, you would have to file a constitution. So another.
Sorry, I think we seem to have a technical problem, Mrs. Oware. Let's give her some few minutes to reconnect, please. I can keep on bringing your questions so that, it will make it quite easier. So please don't forget to put your questions in the chat. And let's answer all the questions that you need to know. She has all the experience and expertise to tell you, because she's been part of the whole process. She was part of the drafting of the company's law, issues about BO, issues about requirement to have company secretary, issues about having auditors change in the if the auditor has been there for like 6 years. These are questions that we should be asking Mrs. Oware. She has all that detail. Let's give her 5 minutes. I'll check up on that, please.
Sorry. Okay, please, exceptions. Please, we can go to the next slide.
Okay.
To the next, if you can go to the next one for me, yeah. Exceptions to the ultra-vires rule continued. Despite the relaxation of the ultra-vires doctrine, the registrar shall not register a name which, in the opinion of the registrar, is misleading or undesirable. A company shall not be registered with the name of a company that has been dissolved within the preceding 5 years of the intended registration. And another thing is, where through inadvertence a name is registered that is misleading or undesirable, and the registrar within 6 months directs that the name should be changed, this should be complied with within 6 weeks of the direction. And where a company defaults in complying under this act, the registrar shall now have the powers to change the name in the register, pending the submission of the new name by the company. It becomes a big problem when a name is clashing with another name in a register, and we inform directors to change the name, and they will not allow you to change the name, and it's through inadvertence, and we are pleading with you to change the name. It can sometimes carry on for a whole year, but now luckily the law allows the registrar at least to change the name temporarily and allow the first name to continue doing business. Now, we remember I talked of the fact that all companies that have foreign participation would necessarily need a constitution, and these are the GIPC minimum equity requirements that a foreign entity would have to comply with. If you don't know, this is it. If you have a foreign partner and you are in a business that is just services, it's $200,000 that the foreigner has to contribute. If there's any trading, whether there's a Ghanaian or not, is $1 million for the foreigner, and the company has to employ at least 20 Ghanaians. So such a company would definitely need a constitution. So please, we can go to the next slide. Qualification for company secretary. Now, under section 211, companies are required to appoint a company secretary qualified to act as such under the act and perform the duties of a company secretary. The law is very clear that in the past, when the secretary is now a thing of the past, this company secretary must have obtained a professional qualification or tertiary level qualification and offering company law practice and administration that would enable that person to have the knowledge to perform that function of a company secretary. Also, this person should have been somebody who's been appointed as a trainee, company secretary trainee, or has held office as a qualified, under a qualified company secretary for at least name of with the Institute of Chartered Secretaries and Administrators or the Institute of Chartered Accountants. If this person is a lawyer, it must be somebody who's enrolled to practice, is in good standing, a barrister or solicitor in the Republic, and then by virtue of an academic qualification too, or a member of a professional body, if the directors think this person appears to be capable of acting as a director, as a company secretary, this person can be appointed as such. Please, let's go on to the next slide. For directors, every proposed director must meet the qualifications as set out in Section 1731 of the Act. The director must not be an infant, a person adjudged to be of unsound mind, a body corporate, or an undischarged bankrupt. The person, whoever is appointed as a director, before this appointment, now is required to make a statutory declaration under Section 13(2)(h) of the Act to the company to the effect that this director has not, within the preceding 5 years of the application for incorporation, been charged with or convicted of a criminal offense involving fraud or dishonesty. Or this person, please, let's move on to the next slide. This person must not have been charged with or convicted of a criminal offense relating to the promotion, incorporation, or management of a company. This director must not be somebody who was a director or senior manager of a company that has become insolvent. And at the point in time, the date of insolvency of that particular company, this person must at least let us know when the company went into insolvency if they want to become a director again. The director must also, for the first time, file a consent letter to consent to be a director. And this consent must be filed first with the company's registered office and within 28 days with the registrar of companies. At least there must be 2 directors to have a company registered in Ghana, ordinarily be residents in Ghana. Please, let's go on. Now, with regard to auditors, an auditor should be qualified and licensed in accordance with the Chartered Accountants Act, Act 170. We need a consent letter. We need a consent letter from this auditor as well to even act as an auditor. A new provision has now been provided. Every auditor now shall hold office for a term of no more than 6 years. Take steps to change that auditor, appoint a new auditor. Whoever has been the first auditor cannot come back to that company, but must stay away for a cooling period of not less than 6 years before that first auditor can be appointed. We have therefore given existing companies with auditors who've been with them for more than 6 years to take steps to have them changed before August 2022 or risk paying sanctions for non-compliance. Disclosures and interest register. It's a new thing, Section 195 and 196. Directors are supposed to maintain an interest register. Why? Because in the past, these kind of things were not disclosed, and you find a director sitting on the board and having his hands in all kinds of contracts. Now you have to maintain this register. You must detail all actual and proposed contracts in which the director is personally interested. And you must also have a location and place where any document containing the details of this interest may be inspected by the other directors. And subject to inspection and subject to reasonable restrictions imposed by the Constitution, it should be open at least 2 hours in each working day. And during general meetings, whoever is attending the general meeting, except where the members determine otherwise by ordinary resolution, should also be allowed to inspect this interest register. Beneficial ownership disclosure. This is also new, and the Act is now making provision for the disclosure. Owner, as I go along, I'll break it down for you, but it's the ultimate owner who owns or controls a company, either through the shareholding or through the directorship of maybe appointment of directors or managing directors to the board and all that. The important is we want to know who is a natural person, not a company. So we've been asked to maintain the central register containing information on beneficial owners. And now each company must first of all set up a register of members and maintain this register by first of all compiling data on legal owners and also now compiling data on beneficial owners of any companies they are managing. And you're supposed to submit this data to us by updating your records, the records of existing companies. This is now a mandatory thing we are requesting from all of you because we have come out with lots. The next slide and show you when you can submit this BO data. You can do it first of all at incorporation of companies. Now, from the 1st of January, every fresh registration has to include the disclosure of beneficial information. So incorporating a company now, you would have to submit the BO data. When you are registering external companies, in the past, how to find out who are the beneficial owners of the external company before you come and register with RGD. Filing of annual returns, you are supposed to be filing annual returns before June 30th. For companies that were registered, whose end of year filing date ended in December 2020, you're supposed to be filing annual returns by end of June 2021. At that point, you have to update us with the beneficial owners of existing companies that you might be managing. You can also amend the BO information by just filling our BO forms on the website and coming to update the registrar with that information. Entities that you need to submit the BO information on now are for both the private and the public companies limited by shares, companies limited by guarantee, and as I said, external companies. So this is the new directive. All existing companies registered before 1st of October 2020 are to update the register of companies with the BO data of their companies. And this has to be done by 30th of June 2021, because after that day, sanctions would be applied if it turns out that you have not updated the registrar with BO data of companies that you already manage. So please, that's the next particulars to be filed. Now, if you're going to be filing BO data, we want to know the full name and any former name of this BO, the date and place of birth, the telephone number, residential, postal, digital, and email address. For those in Ghana, you'd require to submit the TIN of this person because you cannot even register a company here without the TIN. But for those coming from outside, they might not have a TIN. So we can take their nationality, any national identity number that they have, their passport number, or any appropriate identification. We just need a proof of identity. Place of work and position held. You have to disclose the nature of interest. It could be, you have to be detailed and give us whether it's legal or it's financial, whether it's through a security, debenture, informal arrangement, which gives rise to the beneficial ownership relationship. And you have to confirm whether this beneficial owner is a politically exposed person or not. The minister in the Act has given us the go-ahead to make, of course, the minister who is now in place has given us the go-ahead to make legislative instruments and regulations on the procedure for companies. And so in this case, we have come up with some thresholds to help us to manage this whole BO data. For now, we have set threshold levels for the collection of the data. If you are a shareholder of a company in the extractive industry and you have 5% shares in the company, direct ownership for the extractive industry, you would need to be disclosed as a beneficial owner, or in the financial, insurance, real estate, gambling, used car dealership. For the FIC and such bodies, they see these as the high risk sectors that they would like to know who are the beneficial owners in those type of companies. For all other sectors, that is not necessarily what I've mentioned. It's just 20%, so that we are not choked with so much data. So if you are 20% shareholder in any other type of company, you would have to disclose. And if you are a local politically exposed person, even if you have 0%, you have to disclose. But for the foreign PEPs, 5% interest, if you are coming to us, let's say, to register an external company, and there's a politically exposed person in that country of incorporation, if they own just 5% of those shares, you have to disclose. The beneficial owner, these are the sanctions that will apply if you fail to provide us with information. Please, the next slide. A person who fails to provide the information required or provides false or misleading information to the registrar commits an offense and is liable on summary conviction to a fine of not less than 50 penalty units and not more than 250 penalty units, or to a term of imprisonment of not less than 1 year and not more than 2 years, or both. A penalty unit is 12 Ghana cedis for 1 penalty unit. So you can calculate that on summary conviction, the kind of penalties that you will pay if you fail to disclose. And where a company defaults in court, and every officer of the company that is in default is liable to pay an administrative penalty of 25 penalty units for each day during which the default continues. Financial statements. Financial statements. The financial statements and the audits are now to be carried out in accordance with the International Financial Reporting Standard adopted by the Institute of Chartered Accountants. There are new terminologies now in this IFRS. For instance, we are now talking of, instead of surplus, has been replaced by reserves. These are just a few, but there are other terminologies that we can discuss later on. The new act has also brought electronic transactions to the fore, and it gives us the power to authorize the performance electronically through an electronic system approved by us, certain acts. And this includes, please, the next slide. This includes the incorporation or registration of a company, or the reservation of a company's name, the filing of particulars, conversion, filing of annual returns and financial statements, keeping and maintenance of the register of companies, searches, keeping of books of accounts, payment of fees. All this can be done electronically. And this is good. It's good news, because within 2 years, we are going to stop working with hard copies to register a company. Everybody would have to register online. But before we do that, we have to make sure that online registration is easy and is not cumbersome and it's secure. So for the time being, we are doing a parallel system. But within 2 years, we have to stop. The Act says that we should not online. The right to apply for incorporation is now 18 years. It used to be 21. There's no need for a commissioner of oath now. In the past, you'd have to file a Form 4 with the commissioner of oath, but now you can do self-declaration. The company seal is no more obligatory under Section 151D. In the alternative would be accepted in replacement of the company seal. The practice of issuing the certificate to commence business has also been abolished. The minimum capital requirements before commencement of operations, except to meet the minimum capital requirements of foreign companies, has also been abolished. Registration of particulars of charges created by companies is now 45 days instead of 28 days in Section 110 of Act 992. And we have lots of administrative penalties to ensure compliance. All these are meant to promote the ease of doing business. There's a new provision that has come, unclaimed dividends. It didn't used to be there. You know that most companies, and if you're not careful, the companies use those money. So the committee of experts came out with this new unclaimed dividends section. This is the next one, where that's Section 73, where declared dividends of a company remain unclaimed for a period of 3 months. The company must open an interest-bearing unclaimed dividend account, and the company must transfer all those unclaimed dividends into that account. Now, where payment of the dividends cannot be made for a further 12 months after the transfer, the company is supposed to pay this unpaid dividends plus interest accrued to the new office of the Registrar of Companies, because we are going to be opening an interest-bearing account for such unclaimed dividends. And we're going to be publishing details of shareholders whose dividends have been transferred to the ORC in the company's bulletin and dailies. And the registrar will keep this unclaimed dividend for 7 years. After 7 years, if still the shareholders are not coming for, please the next slide, for the unclaimed dividend, the registrar shall transfer, please the next slide, the registrar shall transfer 50% of the amount that has accrued in the interest-bearing account to the consolidated fund. And the other 50%, the registrar will donate those monies to the office of the Registrar of Companies, and will be using it for investor education, research, entrepreneurial development, and advancement in company law. So this becomes one of our sources of financing as well. So upon commencement of this act, all unclaimed dividends must have been transferred to the registrar, but unfortunately, our office has not been set up yet, and we have not also set up the account yet. But once that is done, details will be communicated to the public so that unclaimed dividends can be brought into it. Other reforms that the Registrar General's department is doing is we are a one-stop shop. By that, we are linked up, the next slide please, we are linked up with the Ghana Revenue Authority through our software to generate the unique TIN. And so our systems talk to each other. And through the digital address that is now mandatory, it gives you a temporary business operating permit, which in the past used to take so long to collect from the MMDAs. And they would follow up within the 90 days to give you the more permanent one. And that has helped in Ghana's ranking coming up, because this used to take about a whole month just to get this particular piece of. After we generate all this data, it goes to SNIT, who will also use it to complete their registration to ensure that, so we are a one-stop shop. 7 forms that you need to note.
I can hear you.
Other reforms too, yes.
By
the passage of the Insolvent Restructuring Act, it has been passed to promote a rescue culture and also to promote investments. This Corporate Official Liquidation Act, that is, once you are incorporated, in the Corporate Insolvency and Restructuring Act, Act 101, a rescue culture for companies and also to protect investments. In the past, there was nothing like that. You move from incorporation to being killed through official liquidation. But this new act gives a company that is going through stress the opportunity for an insolvency practitioner or an administrator to attend the business through administration, and also ensure that it gives the company an opportunity as much as possible to continue in existence as a going concern. The temporary management of the affairs and business and property of the distressed company is also assured through this act. And then the act allows the insolvency practitioner to place a temporary freeze on the rights of creditors and other claimants against the distressed company. And they are also able to develop and implement for creditors and shareholders of the company where they would meet. And whilst the company is going through distress, there's going to be a watershed meeting where they can come out with a plan to save the distressed company. And now insolvency practitioners have also been introduced to carry out official liquidations, which was initially the only preserve of the official liquidator. But of course, the official liquidator will have to license you together with Garia to be set up in the yet to be set up insolvency division of the office of the Registrar of Companies. So good things are coming for the business sector. Please, let's go to the procedure for registration. Yeah. Now, you can go on to our website. That's our website over there, www.rgd.gov.gh. You can download all those forms because now we don't sell forms in my department anymore. So before coming to the office, please go to our website and download all the forms and fill it out. So you complete appropriate beneficial ownership forms. Normally it's B01 to B04. You can download the appropriate one that would suit your company. And you attach the following: a director's statutory declaration, auditor's letter of consent, director's letter of consent, secretary's letter of consent. And if you want to come with your own constitution, your registered constitution, otherwise you can adopt any of our 6 types of constitutions that's on the website. Each officer of the company should obtain a tax identification number. But I need to inform you, from the 1st of April 2021, from the Vice President's office, the President mentioned it as well, there is going to be the replacement of the unique, of the tin with the unique national identification number. So when you're coming to RGD from the 1st of April, you would have to provide that number for every director, every secretary, every auditor. We'll need the unique national ID numbers for all these offices. You can select as any of our standard types of constitution if you don't have any registered constitution. And all supplementary forms can also be collected from the website, and they should be uploaded and attached. Once you come into our office, please, if you go to the next slide, you have downloaded your forms already before coming here. You have to follow a queue management system for ticketing, and you conduct a search of the entity name at the desk. You can submit 3 names on a scale of preference, preferably, and you submit your duly filled forms with your tax or NIA number, a digital address now, email, and the company inspector will validate this. Once this is done, you proceed to a data entry officer for data capturing. You pay your fees at the in-house bank. The documents you process at the back office, and you get a notification that your certificate is ready for collection within 5 working days. If it's a company, within 3 working days, it is a business day. And these are some of the documents that you get registration. For the type of companies, if you have a private and limited liability company, you're going to get a Form 3A.
Sorry, we miss Mrs. Oware. I'm sure she will join very soon. But the key takeaway from her presentation is that company secretaries are required to be qualified persons, and she gave us who is eligible to be your company secretary. What is unclear at this stage as to whether existing companies are required to take steps to change their company secretary. So a company secretary must be a lawyer, must be either an accountant or someone with tertiary education qualification in secretary, or a certified chartered company secretary. She also talked about auditors, that auditors now are required to rotate after every 6 years, and existing companies with auditors for more than 6 years are expected to take steps to change their auditors by August 2022. She also mentioned that as part of corporate governance, every company must maintain conflict of interest register, which is to disclose matters that directors of a company have an interest in. She also mentioned about the beneficial ownership. Beneficial ownership has been defined by law, and that definition, you'll find that in the schedule of the Companies Act. But primarily, these are natural persons who are behind a legal entity, whether limited by shares or it excludes partnership. So, I mean, the Act talks about it extensively. So all companies are required to file their BO by 30th of June. That's for existing companies. If you're setting up a company for the very first time, if you don't file your BO, you will not be allowed to have your company registered. So we have to take steps to comply with that. She also mentioned that change of names, that because of the new prefix that has been set out in the Companies Act, every company must take steps to re-register.
I've come.
Which I was just,
good.
Okay, you're welcome. You're welcome. I was trying to recap what you have.
Good.
Welcome,
Good. Let's go to the next slide. But these are some of the documents you receive. Private limited by guarantee, you're going to get a Form 3B, certificate of incorporation, and registered constitution or standard constitution, whichever you want. And the public limited company, you get a Form 3C, certificate of incorporation and registered constitution or standard constitution. Then the public and limited liability company, you get a Form 3D, you get a certificate of incorporation, registered constitution or standard. Public limited by guarantee, you get a Form 3E and certificate of incorporation, registered constitution or standard constitution. And the external company, you get the certificate of registration, the Form 20 and Form 21. Please, let's go on to the fees. These are the fees, our approved fees. To register a limited liability company, to reserve a name is 50 Ghana cedis, for guarantee 50, partnership 50, sole proprietor 50, and an SBN 25. To register a company is 230 Ghana cedis for filing, just to register, incorporation. And then there's a 50 Ghana cedis administrative fee, and 50 for filing of Form 3, no more Form 4. And then you pay stamp duty of 0.5% of the stated capital. The company limited by guarantee, the total sum you need to pay is 270. External company is $1,200 OECD equivalent. Partnership is 160 cedis, and to register a business name is 60 only, and an SBN 60. When it gets to filing of annual returns, it's 50 Ghana cedis to file for each year, and for external companies is $600 or CD equivalent. Partnerships is 50. Sole proprietor is 25 Ghana cedis, and SBN 25. To file for changes, limited company is 110. Everything of the companies is 110, but for external companies, $250 or CD equivalent. Business name is 25, subsidiary 25. Now there's a penalty for late filing of 400 Ghana cedis. This is a one-time payment, and don't let anybody let you pay 400 for each year. It's just flat 400. But next week is going up to 450. This is the increase I've been talking about. Now it's going up. So let's go on to the online accessibility. When you go to our online, you can access our online through our portal www.rgdeservices.com or www.rgd.gov.gh. Once you get there, you're going to create a portal account with a valid email and your TIN, and log into the portal with your TIN as a username, and the password that would have been sent to your email, you add that as well. You can then proceed to register all the 6 entity types. And upon completion, you can make payment, online payment with Visa card, MasterCard, or mobile money through www.ghana.gov.gh. This is our electronic payment platform. You sign up onto it and then you can pay. And upon approval, you can print your electronic certificates with a digital signature of the Registrar General on it and the profiles, and you can move on. You don't need to come to our office. You can do this online. Please, the next slide. And I'll tell all companies that have not re-registered that please make it a point, all businesses registered before December 2011, and you know that you are not in the new electronic database, please ensure that you are re-registered to get a new certificate, to get a new TIN, so that electronically you can be traced. Because without doing that, I take it that you have not filed your annual returns. And what that means is that you are not in operation. And that means very soon your name will be part of the companies that I'm about to strike off the register. And so please make sure that you are re-registered. There's also a mandatory need to change the name of existing companies. Every company must change its name and mandatorily adopt one of the new constitutions. You can do this through a special resolution, and you must have one of the suffixes ending the new name. You should deliver this resolution to us and indicate whether, of course, you come with your registered constitution, because you have to adopt it to suit whatever your regulations were. And the amended name with a new suffix ending should be what is in the adopted constitution. Please, let's go on to the next slide. Filing of returns and group accounts. Every company is supposed to file an annual return, including particulars of every member for the first 18 months after incorporation, and then it should be with a financial statement, and then yearly thereafter. Existing companies are to file their annual returns once in each financial year, and have a financial statement as well. External companies are supposed to file a group account, and partnerships are supposed to renew yearly. Otherwise, the name lapses. So in conclusion, I think I've talked a lot. The duties and rights of companies have been enhanced in this new act. It's supposed to strengthen corporate governance practices and further the ease of doing business in Ghana. By the decoupling of the Office of the Registrar General to become the Office of Registrar of Companies, there's going to be a better delivery of service. There's going to be focus on the business community, and we are sure that you will love our services better than we are currently offering you. Thank you very much. And so Theophilus, I'm in your hands now. Thank you very much.
Thank you, Mrs. Oware, for the brilliant and excellent presentation. It's very insightful. I'm sure my colleagues on the line are learning something out of it. I'll ask a few questions and I'll open the floor for further questions. Ms. Oware, from the Companies Act, and when it was passed into law, it was mentioned that one of the reasons for passing a new law is to improve the ease of doing business, so that our ranking with the World Bank ease of doing business can be improved. I just want to find out from you, what practical measures have your registry taken to ensure that the business community have it easy in carrying out business in Ghana?
The first thing is, we know that currently it's quite cumbersome. I'm sure you faced a few of. I just want to inform you all that the first things first is we need to really get this office hived off. There's going to be a lot of training, change management. The way of doing business is going to change because, first of all, you're going to bring in some of the private sector into this new office that's going to be set up. We're going to be even changing the current software to make it more user-friendly. Once that happens, many of the challenges you have driving through the sun, coming to park here and, giving all these tickets and a long line and, sometimes the attitude of my staff, you won't need to face all that. You will just sit in your various homes and complete every type of process that you could have completed by walking into the office online. And so I just want to assure you that I know will come a bit down the line. But for now, I've already told you we have a one-stop shop. As long as you're able to get the tickets and you get your services done and you pay the on-site bank, we are pushing hard to ensure that we give you your documentation within the timelines that we have given to you. Definitely, I believe that our services are far better than they were before, Theophilus. Are they not? We are still striving to make it better. So for now, for ease of doing business, the first thing is we have deployed the new Companies Act. That will win us some marks. We have also deployed the Corporate Insolvency and Restructuring Act. That will win us marks. We have reduced the steps to do business by bringing on board the other institutions electronically, for instance, the MMDAs, as well as the GRA, the TIN and all that. We have all those offices at our front office. So you don't need to go to those offices for that kind of service. I believe in that light, we have at least been able to collapse some of the steps and the days within which we do business. That should give us some ranking for the ease of doing business. But as to the online bit, we should give ourselves some time.
Hi, Mrs. Oware. This is Jocelyn, Communications Manager at the UK Ghana Chamber of Commerce.
Yes, Jocelyn.
We have lost Theophilus, so I am going to continue on. We have a number of questions from our Q&A chat box. So this is from Yvonne Ochre. She's asking, how will the national ID work? Do people have to apply for this, or it will be automatically generated by GRA? If automatically generated, would all existing persons with TIN be informed of their new national ID number?
Can I respond to that? We will not be the generators of the national ID. I'm sure, Justin, you're aware of that. The national ID is generated by the National Identification Authority. So what that means is that if you are coming to our office to register a business, you would have to come with that national identification number. So if you don't have it, then you have to go to NIA to go and generate it. What we've done is we've been able to talk to them and they would come and replace GRA in our offices for ease of generation. So they came here last week. I think they'll be in place by the 1st of April. So those who do not have NIA, I think they'll be able to generate NIA numbers for them here. That will help immensely. Otherwise, those who already have it should just come to the office with it as they submit their documents. Thank you.
Thank you. Sharon, okay. Theophilus is back, so let me relinquish.
Sorry, I'm very sorry, the internet.
So your internet troubled you?
Yeah, that's correct. That's correct. I'm really sorry about that.
Don't worry.
That is a problem that we face. Yeah. So I don't know whether my question has been answered on the practical steps.
I did. I said that at least we have deployed the Companies Act, the Insolvency Act. Those were some of key concerns for the ease of doing business. And in the Companies Act, we have tried to do away with some of the requirements that initially were bothersome to you, like commission of oath and minimum equity. And we've tried to do quite a number of things for you. And I'm saying that the next one is the online, our online registration. Yes. IFC has come on board together with the World Bank. They're going to assist us with a completely new software, which should be user-friendly and will be such that you would not need to go through the sun and come to our office just to come and carry out business. That is later on down the year. But for now, I think our service is far better than before, isn't it? Theophilus.
That is correct.
But we are working hard to improve whatever we've started. Currently, you can try registering online. Have you tried it yourself?
I use that a lot. It's very efficient.
It's very efficient. Good.
Very efficient,
So
yes.
help is very efficient, yeah, but we want to even make it even better and make it more user-friendly. So more people would use it and not come through the sun just to come and get a service rendered. Yeah, that's what I can say.
Okay, my other question relates to the bio disclosure. Most of the companies that we have come into contact with are concerned about the sanctity of the information in terms of how to be protected so that it is not publicly available to anyone because of political reasons and other economic reasons.
I understand.
So what are the steps that have been taken to protect the sanctity?
The information is only available free to the competent authorities. And that is the law. But to the general public, we are not given information on dates of birth and the residence. We don't give that information. I mean, you only get to know the names of the people, but not every information on them. So I believe they can rest assured that we are complying with the Data Protection Act, and we'll give only the information that is required to be given under the bio disclosures. Yeah. So assure them.
Thank you so much.
Assure them of that. Yeah.
Very, very. My colleague Yvonne Wale asked a question in respect of if you're asking all companies to mandatorily re-register, she thinks there's going to be cost to businesses. So her suggestion is that it's not possible that your system would automatically upgrade companies to the new prefix instead of asking them to do a re-registration and filing a registered constitution and all that.
There are two things I'm talking about here. There are two directives I've given. Okay. Companies that I'm asking to be re-registered are those that have never come into the e-registrar system. Okay. They were registered as far back as 1963 to 2011. Now, such companies, and you'll be amazed, Theophilus, some don't even have regulations. Through this re-registration, they are relying on us to give information as to who their shareholders are. It's very strange. They don't have any records whatsoever. So we need to reconcile that kind of data to ensure that the right information is captured. So I can't just migrate that data into e-registrar because what's happening is they've never filed annual returns. So many of those directors are dead or shareholders are no more the shareholders. So there's a need for them to come with their old documents and then give us documents that relates to maybe changes that have carried on in the company. If there have been share transfers, let's be sure that, because some are also using this opportunity to steal people's companies and making themselves shareholders and all that. If we don't have that thorough, rigorous scrutiny of these documents, you end up having issues. So please, the re-registration is very key to us. Whoever are the current directors of the company, you need to give them unique tax identification numbers. And you need documents to prove how they became directors or shareholders. If it's the same people, you bring the old documents, it's easy for us to just update. So please, that is why, and at the touch of a button, we can give information on that company. All those companies that are sitting, I'm talking about 500,000 of such companies, they are not in the system. When people outside want to find out information on these companies, we now have to look for the physical files. And it's in archives, and sometimes you're not able to trace it, so nothing happens. So please, it's very important to us. But that's the first level.
That's the first one, yeah.
The second level is these companies are already in the system. They're already in the e-registrar system. But you realize that their name endings are LIMITED. And the new act is saying your name ending should be limited company or LTD. Okay. Those are the ones I'm saying you just need to pass a resolution to change the name and also adopt one of the 6 types of constitutions because the regulations relates to Act 179. But this new constitution relates to Act 992, and that is what should govern the operations of your company. That is what the company inspector, the company secretary is supposed to use to guide the decisions of the company. So you can't be having regulations with different sections under Act 179 when we are now in Act 992. So you would necessarily need to change the name and adopt one of the constitutions, whichever is suitable for you. And we have all the 6 types, and it is in Word. So you can change the constitution to suit whatever your regulations were. And that is all you need to come and file with us. You don't need to come and re-register that company with us. Now, for companies that, for instance, in our system were limited liability companies, but are actually public companies, we would have to do a conversion from private limited to public limited. Law firms that are limited, that should be unlimited, because that's what the Ghana Bar Association is requesting for. You have to convert from limited to unlimited. But companies that are already private, you just need to pass a resolution and adopt new, because we don't need to do a conversion. So that is it. It's a big job. It's a big job, but that has to be done so that electronically at the glance, you can know companies that are all public or private. You can tell, and then you can manage them better.
Okay, so my last question before we go to the participants relates to measures that you have instituted in the wake of the COVID-19 to make it easier for compliance by the business community.
First of all, we extended the timelines for filing of returns because most companies could not even hold AGMs. Then we came out with a notice to allow for virtual AGMs to be held, and extended the timeline within which annual returns could be filed. And we've done all that. But when you come on our premises as well, we give out, we do a ticketing thing. We give out numbers. We ensure that the hall is not overcrowded. And as and when the hall gets emptied of people, then we bring in another set. And all our officers, of course, have in front of it, you have to do the normal washing of hands and temperature taking and sanitizers and all that. Yeah, that's what we've done. But to really, for ease of doing business, you should really do all that on the website and online if you can. Then it avoids you coming over here.
All right, I'll take a question from the participant, Adam. He wants to know whether there's a deadline for filing of the Constitution and the mandatory changes of the name.
Yeah. For now, I think by the end of this year should be fine. Okay. For now. Okay. I haven't yet gone, let's see, I'll look at it again by the end of this year, because it's going to be cumbersome for some companies, but I've given this latitude up to the end of this year. You can change the name and adopt the new constitution. Yeah.
I'll take the second question from Abu Nate. He's asking, during the registration, are there any controls to identify and validate the proposed secretary? Is he a member of ICA or Ghana Bar Association, or whether he's qualified as a chartered secretary?
We just have to take their word at that. We can't add that to we just have to ensure, because if you are not given, if you are not truthful, there are provisions in the Act that can be issued against you. So we are just trusting their truthfulness that indeed this company secretary is really qualified to be a company secretary. Some actually submit their certificates, but I can't fill my register, my database with people's certificates. So we just have to take your word for it that indeed you say you are who you are, because you sworn to a declaration on your own oath. So if it turns out that you are lying to us, and of course perjury can be used against you.
Okay. There's a question that relates to whether a person can register a company for the future when that person does not intend to carry out trade immediately.
Of course you can. Those are shell companies. You can register a shell company. You don't intend to really operate with it. The only thing is you have to keep it vibrant on my register by filing returns 18 months after incorporation and yearly thereafter. So in that kind of scenario, you'll be filing what we call a nil return, because you will not have carried out any operation, you will not have commenced any business. But to keep it on my register, prevent me from striking it off, you have to continue
Okay.
filing return. Yeah.
Mr. Oware, in respect of the secretary, the new law says that they must be qualified. So in terms of the existing companies, are they required by law to take steps to change their secretary, or they can still
Yes,
maintain?
yes, no, yes. It's part of the changes. I should have mentioned that. So apart from you changing your name and your constitution, you have to change your auditors if they are more than 6 years. If your auditors are, if you know that you've had an auditor for more than 6 years, and we've given them up to August of 2022 to do that, you have to change your company secretary. If, for instance, when you came to my office, you just use maybe your driver or your wife or your son who doesn't have the qualification to be a company secretary, you have to change that as well. Yes.
So is there a timeline in terms of registering the secretary? Is a timeline
That
for
one
changing?
is this, I guess by the time you're filing your annual returns, you should have done that.
Okay.
So before June 30th of 2021, you see, all these changes, I gave myself up to the end of the year because different companies are at different stages. But it will be very important that as you are filing your annual returns, these kind of changes are done. You change the name, you change your constitution, you change your auditors if you have to, change the company secretary so that you are in compliance with Act 992.
Okay. There's a question from the participant that suggests that the registrar would have to examine whether a person has been disqualified or not by a court, or whether he's subjected to investigation or some legal proceedings. Is there a way to verify that? And also, do you have a register that contains a list of disqualified directors? Because I have checked with the law, it gives you the power to uh, keep that register, but I'm not sure whether we are doing that, because it looks as though the limited liability concept has been abused in this country. And I'm not sure whether any practical steps have been taken to ensure that directors who have been involved in insolvency company, like it happens in the UK, are subjected to investigation and are disqualified, to serve as a signal to the public that you cannot abuse the concept of limited liability.
That's a very good point, and but we'll need collaboration with the courts and with the business community because the registrar is open for any kind of information that we might not be aware of. And that is why these directors are swearing to a declaration that they have not been convicted of any fraud. So if you swear to that declaration and you know that you've been convicted, then of course you want to go to jail yourself. We have to rely on their truthfulness, but at the same time, there is going to be collaboration with the judiciary. We have discussed this with the Chief Justice to ensure that if such judgments are made against any director, the registrar is informed so that we would also have a register of disqualified directors. That is something that we're going to pursue, and it would help us to have that collaboration because I would not know all the rulings that have been made in the court against the director, but definitely the Chief Justice has assured us that they would help collaborate with us in that vein.
Okay, thank you. The final question from the participant relates to whether directors should be publicly, their duty should be publicly enforced in terms of when there's a breach. You would observe from the company's code or the act that the duty of a director has been statutorily provided. So if there's a breach, do you think that it should be publicly enforced or it should privately enforced? By publicly enforcement, I mean you'll be given the power to go after directors who have acted inappropriately and perhaps use your law to surcharge them for breach that amount that is equivalent to the, the damage or the liability occasion to the company. If you go to Australia, for example, they have a similar provision. If you go to New Zealand, they have a criminal provision where the registry has that power to go after directors who have broken their duty. Is this something that you think that we should have it in our in our law, because I mean, the comb of our law doesn't suggest that you have that power. This
Yeah, I don't
that
think I have that power.
this
I
we
don't
should
have that power.
this
Yeah,
something that we
well,
think that we should.
what do you think? What do you
My
think?
view is, my personal view is that I mean, the parliament should give you that power to,
Really?
to enforce it, because at the moment the law is inadequate in that respect. You will see the number of events have happened where insolvent companies have taken a lot of customers' numbers, and at the moment we are in court over a number of them. So when a director breaches his duty and there is no legal requirement to pay similar amount of money for which he has caused a breach, it doesn't send a signal to the public that we mean business in that respect. So from the corporate governance point of view, most countries, and I have done a research in New Zealand and Australia, and they have taken their steps. In the UK, they have a similar one by the Department of Trade, where they can investigate a director and penalize. I think in 2016, they passed a law which allowed the director to pay some compensation equivalent to the damage that he's caused to the company. And I think that will send a signal to the public, because look as though a number of losses have been occasioned to shareholders, creditors, and all that. And I think that
Yeah.
that is why we have the register to keep records of this qualified director. So my personal view is that it's something we have to consider so that we would
Yeah.
improve the business community.
I take your suggestion on board.
Okay.
Thank you.
Any questions? Any question? Anyone who you can raise your hand, and we'll just wrap up. I think we'll bring the curtains to an end. Mrs. Oware, we are most grateful. The chamber is very indebted to you for your kind words, for your insightfulness to our members this morning, for making time out of your busy schedule to share your thoughts with us. From what I take from the presentation is that the secretary must be qualified in line with the Companies Act. Auditors must take steps to change. Company must take steps to change their auditors if they've been there for more than 6 years, and they have up to, I think, August 2022 to comply.
Yeah.
You also talked about the conflict of interest register, which every company must maintain or have a copy similar to the members register to disclose conflicted transactions at the level of the directors, not the shareholders. You also talked about the BU disclosure, which is that companies must disclose who are behind the ultimate beneficiaries of the company. So if it is a legal entity, you have to go beyond a legal entity and find out who is behind it. There are thresholds that have been provided by the registry, Mrs. Oware, and those thresholds vary depending on the industry. Any other sector is 20%, extractive sector is 5%. When it comes to politically exposed, the threshold is 0, if my understanding is correct.
Yes.
You also talked about the fact that we should take steps to change the names, to have the prefix, and to file your register.
But before that, please, all businesses must be updated with bills before 30th of June. Before 30th of June. So all the companies you are handling, you have to take steps to update their registrar of members with the bills, and then update us before 30th of June. Of course, sanctions are going to apply after 30th of June 2021.
Yeah. That is correct. Okay. So the bills, we have to all comply with it. You talked about the financial statements that they have to be prepared in line with IFRS, which has been there in the past, but this time being codified in our Companies Act. You talked about annual returns, that we need to file annual returns, and we have up to 30th of June to file these annual returns. We are really grateful for your time, and I will say that on behalf of the Executive Council of the UKGCC and my very self, we are very happy, we are very grateful, and we thank you. And to all our participants, we thank you so much. The next session will be communicated to you soon, and it will be with the GIPC. We'll have another one with the GRA, and in that order. So very grateful, and have a nice day, and stay blessed.
Thank you. Bye-bye.
Thank you. Bye-bye.